Good afternoon, everyone, and welcome to the Henry Schein Dental Academy webinar series. My name is Adam, Marketing Specialist, and I'll be your moderator. We're excited to welcome back Ali Oromchian as our speaker tonight, as he will share 7 termination mistakes to avoid. Ali is a renowned employment attorney, as well as co-founder of HR for Health. Before we get started, we have a few reminders for you. At any point during tonight's webinar, we encourage your participation. Please type any questions you might have into the Q&A section of your control panel, and we'll answer them live at the end of the presentation. Henry Schein is not offering CE credit for viewing or attending this presentation live or on demand. And this webinar is sponsored by Henry Schein's Dental Business Institute, as well as HR for Health. Ali, thanks for being with us again. Looking forward to it.
Awesome. Thank you, Adam. Hi, everyone. Welcome. We are sort of at a crossroads in our country when it comes to HR and COVID. As most of you know, there's vaccines are being distributed across the country, and more people are getting them, which is great. I actually got my second vaccine just last night, so I was a little bit nervous about how I would feel today doing this webinar, but I'm feeling okay, and thankfully, and I'm ready to power on. But it is a time in our country where we are seeing some abuses, and we're seeing some people take advantage of the various rules that have been passed by the federal government and sometimes by the states. And so this topic on the 7 mistakes to avoid when you're terminating somebody has become more and more important, because we are getting more and more questions, both at my law firm and also at HR for Health, regarding how to properly terminate an employee who is taking advantage of these situations. And it's a fine balance of a variety of topics, and so we're going to go into depth about a lot of them tonight. And the reason why this is important is because this is still your day, and this is kind of what your day looks like as a dentist or as a team member in an office. You're trying to juggle a lot of different things inside the office. And especially now with COVID and all the PPEs that you have to wear, it just has become even more difficult to manage the HR side of the business. And so then this is one of the reasons why, this is important, right? And this is one of the reasons why it's so difficult to manage HR during this time period. And one of the things we see a lot of terminations occurring. Sometimes rightfully so, sometimes, a little bit more of a knee-jerk reaction. But what we want to make sure is that we're minimizing your risk. And tonight we're going to talk about those strategies, about how to minimize your risk so that you have the tools to terminate somebody if you have to. Of course, we don't ever want to necessarily terminate someone, but if we have to terminate them, then we want to make sure our risks are low so that we can do it correctly. Why reduce our risk? Well, because the average settlement in an unlawful termination lawsuit or a discrimination lawsuit can be anywhere from 1 to 2 times someone's annual salary. So someone making $20 an hour could be, bringing a claim for $40,000 to $80,000, if they have been wrongfully terminated. And so we're going to talk about what that means exactly, because you can terminate. There's a lot of reasons why you can. It's just the times that you have to be careful and be aware of. If you want a white paper that we've written on the common mistakes and checklists to avoid, if you text the word termination to 44222, what you'll get is a checklist of how to do a termination. There will be a notice in there on a change of relationship that we provide everyone when they are terminating somebody. And so we're providing this as a gift for all of you who are attending tonight. So feel free to text that word to the number 44222. So text termination to 44222. It'll ask for your email, and you'll get in your inbox immediately. As most of you know, I am a dental attorney. This is all I do. I help dentists across the country with their practice transitions, with lease renewals, employment law, of course, estate planning, and so this is what we do every day. And the things that we're going to talk about are a lot of the stories we're going to talk about are the stories that happen frequently. And so we're not going to go into the things that are rarely happening because they're rare, but the things that happen most frequently that we see most of our dentists kind of fall trapped into, those are the topics we're going to talk about. But more importantly, those are the examples I'm going to provide to you. The stories we're going to share are those stories, so that if you ever find yourself in that same boat, that you know what to do. You know to pick up the phone. You know to call HR for help or call us and get the right advice so that you don't make those mistakes. And I do this, and I show this picture of my family because my wife is a pediatric dentist out here in California, and so I live your life. And everything that we talk about right now are things that I have seen her go through in her practice, in addition to our thousands of clients at the law firm and at HR for Health. So I feel your pain, and that's one of the reasons why a lot of our advice is advice that you can implement immediately, as opposed to just theoretical ideas. So here's what we're going to talk about. We're going to talk about terminations first, right? So what kind of terminations are there, or what kind of change of relationships are there? What exists out there? And this has always been very confusing, but especially during COVID, this has become even more confusing because there is so much similarities and yet differences between the different kinds. So let's talk about what it means to terminate someone's employment. So to terminate someone's employment, as you can imagine, means that you're ending the relationship between the practice and the employee. It's just as easy as that. You are ending the relationship. Now, you could have one reason, you could have no reasons, or you could have 1,000 reasons. And we're going to talk about that in a second. But a termination is a change of relationship that's permanent. A resignation is where the employee has made the decision to leave the practice and has provided you with some sort of notice regarding their employment. And so they could give you notice, they could give you 2 weeks notice, they could give you, 1 day notice, they could give you a month's notice. It just kind of depends on, how much, they care about you and what kind of timeline they want to give you in terms of the ability to start. But they, a lot of times people do give 2 weeks notice just out of courtesy, but they definitely don't have to do that. Now, the next type is the layoff, and the layoff is different than a termination. Although you are ending the relationship, and it's similar in that sense, the reality is that layoff kind of assumes that you're letting go of a larger group of folks. So maybe you're laying off an entire part of your practice. Maybe the entire front office or the back office or the hygiene or whatnot. This was very common, right when COVID was occurring, and the reason was because part of that layoff, there was sort of an opportunity potentially to rehire those employees, right? To rehire those employees, and so you were laying them off for a period of time because the offices were closed because of the of the mandates, put out by the ADA, some of the state associations, and various other governors. But the idea there was that there is a chance to rehire those employees back once the termination happened, or once, I should say, the layoff happened. And then finally, furlough. Now, furlough is a kind of a temporary reduction of the employee's hours or days because of office closures, mandated closures because of the state orders. So these are things, again, very, something that a lot of dental practices had absolutely nothing to worry about, didn't even know what they were, didn't even do them before, COVID. But then as COVID occurred, there was a lot of furloughing happening of employees. So the employees in those situations are still active, they're still considered, part of the practice, but they're furloughed for a period of time, while the office is closed. And this is something that if can somebody be furloughed for an extended period of time? Well, usually if they're furloughed for 2 weeks, then it's sometimes deemed a termination. Some of those rules became a little bit more relaxed during COVID. Now that we're sort of on the tail end, hopefully, and we're coming out, some of these rules are trying to be more clarified now. And so we'll see. But these are the 4 different kinds of change of relationships or terminations that you need to sort of be aware of. Okay, so now let's go into the 7 primary mistakes to avoid during a termination, right? And these, again, are the most common things we see in a dental practice. They're not everything that's out there, of course, but the most common things we see in a dental practice. And terminations are hard. No one ever looks forward to them. But by having a system, by having a strategy, by having it written down, in knowing kind of what you want to do when something like that happens, really takes a lot of the guesswork out of it. And you won't get it right every time, but it limits the chance of errors happening, which again prevents any future legal disputes and also protects you as an employer, because employees do talk to one another about what kind of employer you are. So let's jump into it. The first thing is ignoring the probationary period. Now, the probationary period is a little bit of a funny thing because everyone's heard about it. Everyone knows that it's usually 30, 60, or 90 days, 90 days, of course, being the most popular. But what truly is a probationary period? Well, a probationary period is something that was created by HR professionals as a evaluative tool in when you hire an employee. In other words, you have 30, 60, 90 days to evaluate whether you want to keep this employee in your office long term. It does not mean in any sort of way that the laws have changed with regard to that person's employment. So you still have to, give them lunch and pay them overtime, and you can't discriminate against them, and you may not be able to fire them, under certain circumstances, if they're pregnant or whatnot, which we'll talk about later. But it doesn't change the legal aspects of the job. It just changes the fact that it's now an evaluative period. And so what we recommend, right? What we recommend is that when you hire a new person, is that you do a 30-day review with them to see how things are going. If there's things that they're doing well, you tell them that. If there's things that they're not doing well, you tell them those. And you create a plan for them to improve in the next 30 days so that when the 60-day review comes, you are sitting down with them and talking about, hey, like, these are the things that are going really well, and these are the things we talked about at the 30-day review. But guess what? It's now 60 days, and I'm only seeing improvement in a couple of these, not in all of these. Or it might be the other way. It might be, oh my gosh, you're killing it. You're a rock star. You're doing really well in all of these categories. And then you track new things for the 90-day review. That way, at the end of 90 days, you can make an educated guess about whether or not you should keep this employee because they're a long-term asset, or maybe get rid of them. Now, can you get rid of them just quickly and without any thought? No, you have to be careful because wrongful termination claims can be brought in those kind of scenarios. So you just have to be careful about how you do it and when you do it, and for the reasons that you do it during a 90-day, during the probationary period. So just remember, the probationary period is a really great tool. It's really fantastic to use as an evaluative tool, but it doesn't change the legal obligations that you have as an employer. And if you decide that at the 90 days you do not want that employee, then you want to make sure you have proper documentation, hopefully all electronic. You have proper documentation showing kind of what efforts you went into keeping them and trying to help them improve, so that there's no wrongful termination type of claims that are brought. In 2019, there was over 72,000 claims of wrongful termination or discrimination filed, and which is a crazy amount. And the average settlement was about $37,000. So it's a crazy number. It's a crazy time, and this is for silly mistakes, right? It's for silly mistakes like this, when we maybe sometimes terminate somebody without realizing it. Okay, so the next area is not complying with final paycheck laws. So every state has its own final paycheck laws. Some states require you, if you're going to terminate somebody, to pay them that same day. Some allow you to pay it, at the next payroll. Some, have even slightly different rules than that. They might give you a few days here and there. Now, if somebody resigns, which we'll talk about later, it's slightly different. But you got to know what your final paycheck rules are. This is really important because if you don't know your final paycheck rules, this is where most of the penalties accrue when it comes to final paychecks. And so where does it occur? Well, usually it's around PTO, paid time off, or vacation. If you haven't paid someone correctly for those things, then those are the things that sort of really become an issue, right? Really become an issue because you haven't done the calculations correctly. you've mispaid someone, you haven't paid them everything, and then they come back and make those claims against you. So you want to make sure that you're doing all the right calculations. If you're using a payroll company, don't rely on their data. Make sure you're focusing on your data to make sure it's accurate, because sometimes they're usually not tied to time clocks. HR for health system is tied to the time clock. So when they clock in and clock out, and then they file, run payroll, that those hours are absolutely tied in. But you just want to run a report and make sure you know exactly how much paid time off or whatnot is there. And then make sure it's in your employment manual as well, right? Those final paycheck policies and whatnot need to be in your employment manual. And so between the systems, hopefully being integrated between time clock and payroll, and then having your employment manual, you're in really good shape with the final paycheck laws. But again, if you have any questions about it, that's the time to raise your hand. And remember, our goal is not to do terminations in a knee-jerk fashion, right? We don't want to do them quickly. We want to kind of be thoughtful about them. We want to have documentation. And then once we make the decision that we're going to terminate somebody, there are some steps that we have to follow, like we're going to go through tonight. And so by doing them deliberately like that, the chance of errors really falls pretty significantly. So just kind of keep that in mind. And again, the laws can be complex, so don't assume. Let us know if you have any questions. We can answer any questions that you have about it. Now, not keeping documentation during a termination, huge mistake. Terminations they're stressful for everybody. They're a big deal. No one takes it lightly. Although sometimes employees think you take it lightly. I know you don't, because one, it's hard to find good employees. Two, usually, you've tried very hard to improve performance. You've had informal discussions, you've had formal discussions, and at some point you just sort of reach the end of your rope, and you feel like that's the only thing that's left to do is to terminate. So that I can understand. You just want to make sure you have the documentation to show all of that. And so what we recommend is that you do an oral warning first, which you document, but the employee doesn't have to sign. Then you do a written warning, and there the employee does sign that. And then you do a final warning before termination. And the final warning, the employee signs as well. Now, these are minimums, right? These are minimums. What I mean is you can have, 5 oral warnings, 10 written warnings, 2 final warnings, and then a termination. So those numbers, the initial, doing 1 of each is really a minimum, but you can do as many as you want. But you want to be consistent with it, and you want that documentation to be absolutely clear, right? Absolutely clear, so that if the employee says, no, he or she didn't fire me because of this reason, they fired me because I'm tall, I'm short, I'm white, I'm black, whatever. Well, guess what? You have the documentation to show otherwise. And that is where it becomes really, really important, right? It becomes really, really important because at the end of the day, the documentation is going to save you, and you're going to avoid these sort of he said, she said types of claims, right? These he said, she said types of claims. So just kind of remember that. Relying on at-will employment, every state except one is an at-will state, which is great, except that, I call this the at-will conspiracy, because there's this false notion that just because we're in an at-will state, that you can fire anybody for any reason. And the reality is that there are so many laws in each state that talk about discrimination and unlawful terminations, that just because you're at will doesn't mean you can terminate the employee. You have to be very, very careful. And keeping detailed HR records so you can back up your decisions for the termination, like we just talked about with the previous slide, are vital, right? Are absolutely vital. Now, the funny, not so funny thing is that a lot of times these files that we're talking about, these employee files, guess what? They kind of disappear when someone's about to get fired. Now, no one ever thinks they're a bad employee, right? Everyone thinks they're just an amazing employee. So they're always surprised by a termination, but they also know it inside their gut that something's not right? They feel something. And so that's when, we see employee files and employment files sort of disappear. So, if you're not doing things on HR for Health, you're doing things kind of, on paper still and whatnot, make sure you're storing them in a super safe place under lock and key. And don't put the key somewhere that's easy for someone to find. make sure it's with you or somewhere else that's safe. These are the ways to really truly minimize your risk with at will. Now we'll talk in a second, but as at will, if you've ever heard me speak before, that I always say, there are three moments in your career where you don't want to let someone go, and those are, when someone's pregnant, old, or disabled, and we'll talk about that in a second. But that is an example of something that doesn't matter if you're in an at-will state, you just don't want to let them go. And believe it or not, between 2010 and 2017, so in just 7 short years, there were over 1 million cases of wrongful termination and discrimination filed. And by the way, these are against big employers and small employers. So you are part of that. And if my law practice gives you any example of this, I can tell you there's a lot of that happening. All right, next let's talk about resignations and terminations. And so, when someone resigns, it's always better for you as the employer. It's always better for you. They give up a lot of rights. There's a lot of claims that they can't make anymore. Whereas a termination is a little bit more risky, and it's a little bit more on you. And so how do you sometimes change a resignation into a termination? Well, what happens is that someone comes to you and maybe you're having a bad day, or maybe the case didn't go so well, or maybe you're having an issue with another employee or at home, and you're just sort of on stress, right? Like you're just worried about it, you're concerned, and then somebody comes to you and they say, hey, I'm sorry, this isn't working out, I'm resigning. And at that moment in time, your reaction is like, you know what, just go, today's your last day, just leave. So now at that point, you have turned that resignation, which was to your benefit, into a termination, which could be a problem. Now, it could also not be a problem, but if it is a problem, then you've just sort of walked right into it. So there's a couple of things you can do in those situations. One is you could allow them to work the remainder of the time that they they gave you notice for, so like the 2 weeks, and then you wind down their projects and whatnot. Now, in a lot of dental practices, that's not realistic. What we see a lot of employees acting out. They say things to patients, they say things to other staff members. They just sort of act out in sort of negative ways that cause even more conflict than before. And so option number 2 is also available, which is you send the person home. You keep them employed for, let's say, the 2 weeks that they gave you notice. You don't fire them, but you don't have them work either. So you're paying them without working, and that's okay. And that's how you can maintain a resignation as a resignation, which is by simply just paying them to work the next couple of weeks. They stay home while you sort of ramp down everything else. It's a little bit counterintuitive, and you say, well, why would I want to pay somebody who's not quitting or who quit? Well, you don't want to, but for the betterment of your team, for the betterment of the practice, it's always a good idea. And I'll tell you, probably 6 out of 10 times that when somebody doesn't do that, it turns out to be a problem. The employee, whether they're a doctor associate who's leaving, or an office manager, or a hygienist or RDA, they end up, downloading patient information and taking it with them, just doing crazy things, taking marketing material strategies, they just do things that they shouldn't be doing. And so this definitely increases your legal risk when you are turning a resignation to a termination. So please be careful of that. If somebody's quitting on you, just take a deep breath. If you have questions, call us. If not, just let it sort of occur. All right. Number 6 is terminating a member of a protected group. So you can probably imagine what those protected groups are. We talked about them a few minutes ago. If someone is pregnant, if someone's older, or someone's disabled, you want to be very, very careful about terminating these folks. In fact, ideally, you won't terminate any of them if they fit into these 3 categories, because it is super, super high risk. Now, terminating a pregnant employee, especially in this day and age, has become a lot more difficult. A lot of states are passing new laws protecting pregnant employees after they give delivery. Some states give 3 months initial leave, and then 1 additional month for if it's a disability or a C-section. And then they've added to that. They've added another 3 months sometimes, for baby bonding and other protected leave. So it could be 6, 7, 8, 9 months, after delivery that someone could be out on protected leave. Now, does someone take all that time? Sometimes, sometimes they need to come back to work, and so they come back earlier than that, but that's available to them. The issue is if you terminate them at any point during that timeline if they're pregnant. So you just want to be very careful about that to make sure that you're not doing that with a pregnant employee. You're sort of stuck with them. The next group is the age group. So if they're older, if they're approaching 50, 60 years old, that's when it starts to get really risky. Don't shoot the messenger, but the technical rule around the country is 40 years or older is when they're considered sort of old, which is a ridiculous number. And so, but that being said, it is the number, but the number that we recommend against is 50 to 60. As they approach 60 years old, that's when it starts to become a little bit more risky. And we see this a lot with younger dentists who recently bought a practice or are buying practices, that person up front who's been working there for many years, may not be familiar with the new dentric system, or they may not be familiar with the new x-ray units and things of that nature. And so they become, it becomes a little bit more difficult for them to work with this new buyer. And that's when, the terminations occur. So just be aware of that. And then finally, if someone is disabled, and disability, has such a, it has a vague connotation to it, although it actually is very specific in terms of what's considered disability. But what has happened is that so many of these rules with the state judges and whatnot have kind of made it even broader. So the technical kind of rule, if you will, with a disability is that if somebody can't dress themselves, bathe themselves, feed themselves, or protect themselves, that they are considered they are considered sort of disabled. And so the bathing, eating, and dressing are really the core of it. And so most things kind of fit into that category. But they've expanded the rules. So now psychological effects could be considered a disability. Other disabilities could be like alcoholism, tobacco abuse, if you're on medication, that could be some sort of disability. So it's the definition has sort of broadened, and so you have to just be careful with any kind of injury or any kind of thing having to do with disability, because it could open up a can of worms. And so just be aware of that. You want professional help anytime you want to get rid of anybody in these three categories. And now with COVID, coming out and some people being diagnosed as sort of long-term, folks with like sort of long-term problems related to COVID. It's not anything that they get better on. These topics are going to come up more and more. And this is the area that we see the most abuse, by the way. I started off the webinar today talking about that. We wanted to do something specific on terminations because more and more people are abusing these leaves, and so which is leading to terminations. And as a result of that, you just have to be kind of very, very careful. So be aware of these. Plaintiffs win a large majority of these cases, but if you have good documentation, if you're on HR for Health and you got good documentation, you're showing all this stuff to a judge or a jury or an administrator, your chance of winning goes through the roof. But if you don't have electronic documentation, you don't have timestamps, you don't have those things that prove that you're not discriminating, then of course you're fighting an uphill battle. And I'll tell you, one of the main things too, with a lot of this documentation has to do with making sure that you're interacting with the employees through the interactive process. You're accommodating them if they need to be accommodated, which could be as easy as changing a schedule or giving them different equipment, putting up plexiglass, sometimes changing their job duties. But all of this needs to be documented. Otherwise, all of the good deeds that you're doing will be forgotten, and I guarantee you the employee will change their tune and claim that you haven't done any of those things or you've done it poorly. Okay. All right. The final thing, not the final thing, but the next thing is giving it too much information. So the more you talk, the more you dig yourself in the hole. So you want the reason for the termination to be concise, and you want it to be precise. Now, a lot of people will tell you, don't give a reason for termination. You don't have to give a reason for termination. So why give a reason for termination? Just let them go and move on. But I can tell you from human psychology that we are all, rational people in the way we think about ourselves. And like I mentioned, no one ever thinks they're a bad employee. So if you don't give an employee a reason why you're terminating them, now, don't get me wrong, it doesn't have to be the whole truth and nothing but the truth, right? You don't have to go through a laundry list of all their issues, but by not giving them at least one major reason, what happens is that they start to rationalize and they start thinking about the reasons why you're terminating them. And I can guarantee you it's not because of their job performance. It's going to be because, he's discriminating or she's discriminating against me because I'm tall, I'm short, I wear glasses, I don't wear glasses, I rent versus buy, I'm religious versus not, I'm white, I'm Asian, I'm black, I'm whatever, right? Like they just will come up with any and all reasons why you let them go, right? And probably none of them are true, but they think it is because you're not giving them a reason, right? Because you're not giving them a reason. So it's important to give them a reason, but again, don't go through all the details, right? You don't have to go through all the details. It's already a stressful time. It's already, they're not going to be happy, but hopefully it's not the first time they're hearing these issues. So if you've done it correctly in terms of performance reviews and some documentation, ideally, they've had some warning, and more importantly, they haven't necessarily done whatever they needed to do to better their performance. And so then, you're kind of just left without any choice. So just kind of keep that in mind. There's been a huge surge, a 70% surge in defamation claims and discrimination claims, in 2018 to 19, and now, we don't have the numbers yet going into 20, but there's a huge surge happening, right? There's a huge surge happening, and so these are the times when you pick up the phone and you talk to one of our HR specialists or me, and you say, how do I navigate this, right? How do I navigate this? And once you do that, it just lowers your risk immensely. But because it's a stressful time for everybody, you're nervous, they're nervous. Sometimes we just give too much information. And that's the key. We want to avoid giving too much information. Okay. The next thing is fighting unemployment. Now, this is a bonus. This is something that, we usually do on our one-on-one consults with our clients, but this is something that statistically we have seen happen open again and again and again. If an employee files for unemployment, do not fight it, right? Do not go against it. Do not try to reject it. Do not try to win. It is an emotional time. It's an emotional subject, and the employees, they don't understand why you're fighting it because it's not coming out of your pocket, at least not directly. And so they get really upset. And so if you fight unemployment, there's an exponentially more chance of you getting sued, regardless of whether you win or lose. Regardless of whether you win or lose, your chance of getting sued exponentially goes up. So just don't do it. Now, for those of you who are thinking, Ali, I don't understand. If I lose unemployment, then my account gets hit and then I pay more. So let me tell you a couple of reasons why it's not important to fight unemployment. The first reason is that your unemployment rate is only partially attached to your account. In other words, your unemployment rate, how much they take out and whatnot, is tied to not just your account, but also the entire unemployment account of the state. So if there's more people unemployed, then there's less money in the state's account, and so they force all the businesses out there to pay more in order to increase their reserves. So it's only partially tied to your own personal account. It's tied to the overall situation at the state. Okay, so that's one reason. The second reason is that this is a soft cost. You have paid into unemployment every time you run payroll, and you continue to pay into unemployment. Then they use that account, right, that money in that account, and to pay for these unemployment benefits. Now if you have a lot of them and you're early in your career, you don't have a lot in your reserves. Of course, it can go in the negative. But after a few years, you end up kind of increasing your reserves, and so that's what they use, right? That's what they use. So you've already paid into that, and you don't get that money back. You don't get that money back. Once you pay into the fund, it's gone. They show you how much you have, but it's not really yours, right? They don't ever give it back to you. And so it's a soft dollar cost. In other words, you've already paid into it. You're not paying it again. So, and then some of you might say, well, what if I might end up paying a higher percentage? You're right. You might end up paying a higher percentage if the first thing, it happens, and then, and you don't have a lot of money in your account. But there is a cap. Almost every state has a cap per employee. So if you have a full-time employee working for you, sometime in August, September, you hit that cap. And once you hit that cap, it doesn't matter what your percentage is, you're not paying any more for that employee, or for that employee. So if you've got a lot of part-timers, like your entire office, is part-time, they're 1 day, 2 days a week, then maybe there's a slight disadvantage to you. But if you've got, employees working 3-4 days a week, you're going to hit the cap at some point during the year, and then that's it. So, you just end up hitting it maybe a little bit faster, if your rate is higher. So my point is that, with those three things in mind, and then on top of that, the fact that your risk of exposure to a lawsuit is exponentially more, it just makes no sense. It makes no sense for you to fight unemployment. I wouldn't even return their phone call. I wouldn't return documents. Just let the employee have it, and hopefully they just ride into the sunset. Okay. All right. So we are here to support you at HR for Health through our partnership with Henry Schein, through all of your HR needs, because terminations can be overwhelming. And the reason we've partnered with Henry Schein nationally on this is because we want to make sure that you have an HR department, specific for your practice, because you're not a Fortune 500 company. You don't have people that you hire who have masters in HR and who have an entire department. So we are here for you. We have HR specialists to answer your calls. If they can't answer it, they'll transfer you to lawyers who will talk to you about it. And then of course we have an entire system that's paperless, to manage everything from hiring to performance management to time clocks to payroll for you. So I strongly urge you to look into that, because between documentation, having your proper payroll records there, having your time clock records, and your new hire paperwork all in one place, all electronic, in a safe place, you're already well in your way to compliance. And here's the added bonus, that you get an employment manual from HR for Health for free every year that's customized to you. So now you don't have to pay lawyers like me and others thousands and thousands of dollars to get an employment manual. Put that to rest, right? That's a cost savings to you, because we're giving it to you and it's updated every year. So as we end tonight, I want you to take a moment, as this is sort of your moment of truth, which is, what are you going to do next, right? What are you going to do next? And the reason I say this is because you've sat through this. Hopefully you've asked some questions, which I'll go through as we finish tonight. And the question is, what are you going to do after the seminar? Are you going to remember all these things tomorrow and Monday and Tuesday? Probably not. And so what I urge you to do is to write one thing that you learned tonight, one thing that kind of stuck out at you that is important for you to know, and write that down, that you're going to do this in the next 7 days. So it could be something as simple as, I'm going to call HR for Health and do my free HR audit to see how compliant or non-compliant I am. I'm going to get those strategies so I can fix my office and make sure I'm HR compliant. Then I want you to write something that you've learned tonight that you're going to do in the next 14 days. And that could be, I want to get all 12 to 18 new hire documents. I want to get a new employment manual. I want to switch payroll companies because my payroll company is bad. And then finally, one last thing that you're going to do in the next 21 days. And This could be as simple as, I just want to get an employment manual. I'm tired of spending a ton of money on it. I want to get my HR house in order. By the time, spring comes, by the end of this month, you will have done an incredible amount of work towards being HR compliant. So I strongly urge you to write these 3 things down and then make sure you do them in the timeline, because it's a funny way when we tell the universe what we want to do and we write it down instead of keeping it in our heads. Things start to happen, right? Things start to happen, and we start check marking stuff, and you'll do 3 major things towards HR compliance. For those of you who missed it in the beginning, if you want a checklist of the termination mistakes and a change of relationship notice form, please text the word termination to 44222, and we'll get that to you immediately. If you have any questions about that when you're filling it out or whatnot, let us know. Of course, that's what we're here for. And for those of you who want to learn more about HR for Health, get your free HR audit to see how compliant or non-compliant you are. There's no obligations. It's sort of like our gift to you so that you sort of know where you stand, and then you can kind of plan accordingly. Just go ahead through that link that's on your screen right now, and you can schedule a time with one of our HR compliance folks, and they'll walk you through and make sure you get everything you need. So, Adam, I see a bunch of questions coming up. Do you want me to go through these? One by one?
Sure, go for it.
Awesome. Okay, so let me start from the top. Can we ask an employee to get COVID vaccine as part of the hiring process? And yes, so you can require the COVID vaccine as a requirement of the job. That is something that is allowed. You can, you can have them show you proof of it as well with their card or whatnot. You don't want to dive in too deep into any other medical issues with them. But if the vaccine is sort of one of those unique things in our history where some exceptions are being made. But yes, you can do that. Someone in all caps wrote, what if employee doesn't want to sign a warning? If they don't want to sign a warning, see if you can get them to at least initial the document that they refuse to sign the warning. That's almost as good as them signing it. But there's only so much you can do. I think what I would do is, I would send it to them. If you're doing it electronically through HR for Health, the nice thing is that we keep track of when things are sent with a timestamp. So it shows when they received it and when it was sent. So even if they don't sign it, we can show that it was received and reviewed, and that's good enough for compliance. But ideally, of course, they would sign it. So, all right. Then we got another question: is that I terminated a hygienist for professional misconduct, seeing a patient after hours without my permission, not putting him in the schedule, and not charging him. Also, she has been receiving COVID family leave for 3 days a week. She was cited working at her family store by 2 people while receiving this. Can I dispute her claim for unemployment once her 2 weeks of COVID family leave in lieu of notice is done? So there's a lot to unpack here. It does sound like a terrible situation that you've got, Farah. And what I would tell you is that if she's no longer working for you, and she's filing for unemployment, then yes, you can do that. But again, I'm not sure that I would recommend it if you end up being the one that fires her. If she's still working for you and you're terminating her, then I wouldn't fight unemployment. If she's cut her own days down and she tries to file for unemployment because she wanted to work at her family store, the likelihood is that unemployment will probably deny her simply because it was her decision to cut her hours, not yours. And you can let unemployment know about that. If you have any more questions about that specific situation, Farah, feel free to email me or call me. All right, the next question: resignations. If you find out they are working somewhere else instead of staying home and you're paying them, can you withhold pay? No. So that's kind of like a termination. So I'm assuming what you're asking is, if someone resigns, you tell them, hey, you don't need to come to work. We'll pay you for the next 2 weeks, and they go work somewhere else. Can you withhold their pay? You could, but then that's going to be considered a termination at that point. And so remember, you at that point, you don't care, if they work at Starbucks as a barista, during those 2 weeks, or they're working at another practice, you just don't want them in your practice to cause damage. So I would pay them for those 2 weeks and just kind of put it behind you. Next question: if someone says, due to health reasons, I can't come back to work full time, but then 5 days later they might be able to come back, must you take them back? So it depends on what those health reasons are. If it's something that's not a disability, like a broken bone or whatnot, then not necessarily. You don't have to if you've already changed schedules and things. If it's more of a disability reason that they can't come back, then you might have to bring them back to their old schedule. But what's important there is to make sure you document everything so that, if someone's requested change in their schedule and you've made a permanent change, you may not have to bring them back to the old schedule unless that change is considered sort of a temporary change because of a reasonable accommodation or something of that nature. Okay. All right. Next question. If an employee comes into work under alcohol influence, can this be cause for immediate termination? Absolutely. Absolutely. Yeah. If someone's coming in drunk on alcohol or they're on some sort of substance, can you terminate them? Yes. What you want to make sure is that you've got not just your opinion, but maybe another staff member or an office manager who also gives an opinion about whether they smell the alcohol or whatnot. But I would talk to the employee with maybe your office manager or someone else in the room. See what they say, and then you can terminate them. The only caveat there would be if you know that they're an alcoholic and they've kind of indicated that to you, or that they're going to AA and things of that nature, that could be considered a disability. So you just have to be careful about that. But if it's if they just went and had a couple margaritas more than they should, then yeah, that's putting patient safety at risk, and that's a good reason for a termination at that point. Okay, next question. What happens when you have an employee that is 67 in 2 months and wants to work for 2 more years, but you have an excellent candidate in waiting? Ron, that is a great question. That is your primary risky situation where, if you let go of that person, but you could potentially be opening yourself up to some age discrimination lawsuits. What I would recommend is that, if possible, if you can afford to do this, is to have the candidate who is sort of waiting in the wings, bring him on board, train them, teach them how to do things, and maybe you have both working for a while until the older one retires. There are other ways you can potentially convince the 67-year-old to maybe retire early, but it will require a lot of finesse in your discussions, because you don't want to imply that you're terminating them or anything of that nature, without really good documentation. The age really becomes an issue. It really becomes an issue. I mean, I can't tell you how often we've seen a case where there is no case. There should never have been a case. But a lawyer files a lawsuit simply because someone's older. So if you want to chat with me about how to create good documentation to let that person go, just shoot me an email, and I'll be happy to kind of walk you through that. All right, next question: should we be purchasing an insurance policy to protect us against the lawsuit? So there are some insurance policies against lawsuits from employees, but they're very expensive. I mean, we're talking about $10,000 to $15,000, for a small office of 5 to 7 employees. It's sort of a ridiculous policy, and on top of it, most of these policies do not cover the most common lawsuit, which is called wage and hour, which is not paying someone overtime and wages correctly. That's the most common lawsuit against dentists, and it's not covered by these insurance policies. So my recommendation would be is get on HR for Health. It's going to be your best insurance policy, because they will minimize your risk so significantly that although nobody can take you to zero, they'll significantly reduce it so as to be a disincentive for a lawyer to sue you. And that's something that we see all the time. Our clients who get sued, who happen to be on HR for Health, or maybe not sued, but they get a letter from a lawyer threatening a lawsuit. when they see all the record keeping and they see all the information we provide to them, I mean, the lawyer is not crazy. He doesn't want to fight an uphill battle. And so a lot of times we're able to get rid of it or settle it for very little. And that's the best insurance that you can have. Are those three categories you see the most? What about race and sexual orientation? So great question, Elizabeth. Yes, race and sexual orientation are not common in dental when it comes to those risky categories. We do see them in other areas actually of healthcare, but in dental, the top three are age, disability, and pregnancy by far. Very little do we see race and sexual orientation. So good question. Is it legal to get a signature from the employee at the time of termination to waive all their rights and there will be no claim? So Rezwan, depending on the state that you're in, you could potentially get something like this. There's two sides of this. Some states absolutely don't recognize anything that's given like that to an employee to sign at the time of termination because there's a lot of things that they sign and sometimes it kind of derails actually the conversation because you're hoping to end it somewhat amicably, but unfortunately it doesn't always work out that way. But the other way you could do it, and this can work really, really well, and it works nationwide, is you can give something called a severance agreement. And a severance agreement, basically you buy the employee out of their job. You're saying, here's some money in exchange for you to be terminated, but you got to sign this document that says you'll never come back and sue me. And that's a great way of protecting your interests, and it's almost 100% guaranteed that they can't come back and sue you for anything. It's just that you have to balance the conversation a little bit because it's tricky in terms of getting them to sign the severance because although it doesn't always mean this, it could, they could assume that you're doing something wrong. All right. The next question: do you represent employers or do you represent employees? No, we don't represent any employees. We only represent employers or doctors. If you're a doctor, suing another doctor, we may represent you there, but we don't represent any non-dentists. So. Next question, can an employee ask for time off or change a schedule due to childcare problems due to COVID? Yes, they can. There's a lot of protections for childcare during COVID. Some of those have been are now no longer required as of January 1. That means you can choose whether to provide FFCRA leave and things of that nature. But you want to be careful with childcare. These days, it is sort of a touchy subject in many ways. Now, some states are passing new laws to make the rules that were passed during COVID more permanent, which it's terrible. It's terrible. But they are passing it, and they're going to make it retroactive too, which is even worse. But right now, a lot of those are still being negotiated. All right. We have an employee whose health is getting worse and worse and wants to go part-time. She tends to miss work off and on. We need 2 full-time assistants and cannot function properly with her as a part-time employee. Can we get in trouble for letting her go? She has brought it up twice. That all depends on what the health issue is that's getting worse and worse. If it falls into a disability, then you could get in trouble for letting her go. If it's not a disability, then you could be okay. Okay. Next one. Do you recommend that all warnings termination be sent via email versus face-to-face? So, Kathy, you can definitely have the conversations face-to-face. We recommend that, and face-to-face, by the way, can be like via Zoom or whatnot too. But we always recommend doing things in writing afterwards. So you want to summarize everything that happened afterwards in email, so there's no confusion about what was discussed. So warnings, performance reviews, all of those things. Yeah. What are the liabilities regarding using an extern or student employee as part of the training program? So you got to be careful with interns and student employees. If they're getting credit at school and they can prove that, you could be okay. Otherwise, you should pay them at least minimum wage. I know that's different than what most of us grew up with, because usually if you're an intern, you're not, you're just getting the experience, you're not getting paid. But so the laws have changed regarding that, and people were abusing interns and others, and kind of people were not really interns, they were or whatnot, they were just sort of normal employees, and they were being convinced to work for free. So if they're not getting credit for school, if they're not a student, then I would definitely pay them at least minimum wage. Now, that being said, you do have to follow all the same HR rules in terms of hiring and whatnot, in terms of making sure they have all the documents. So I would just be, mindful of that. What is the best way to use the hire and fire at will? Making sure you have good documentation, making sure you have an employment manual is very important, and then making sure you're careful about who you terminate at will. Because as I mentioned earlier, there may be situations where you can't terminate somebody at will. All right. Next question. Do you have to give warnings before termination if the employee has aggressive behavior towards the doctor and staff? How would you recommend terminating this person as easy as possible? So you don't need to do a warning before termination if you don't want to. If the act is egregious enough, right? If it's bad enough, they threw a handpiece, they swore, in front of a patient, or maybe not even in front of a patient, in front of staff members, they're shoving people. If it's egregious enough, and there's documentation, and what I mean by that is, there's witnesses and other people you can terminate somebody without having to give a warning. Of course, if you give a warning, you're protecting yourself, but that's assuming you think this person is going to change their behavior, or that you care enough to want them to change their behavior. So just sort of keep that in mind. Do you recommend for HR to always have a witness in the room when having a final write-up with an employee that you either potentially plan to let go or plan to terminate? Yes, Stacy, we do. If you can have an office manager or office administrator in the room, I think is a great idea. If you have a consultant that you work with, having them in the room, having somebody else during those kind of super stressful times, I think is important. If you cannot have somebody there, then what I would do is I would have the meeting. Try to keep it as amicable as possible, if that's even possible, and then just follow up immediately with an email summarizing sort of what happened, so that if anybody says otherwise, there's written proof of what you did in real time. So I don't want you to have the meeting without somebody present and then send the email a week later or 3 days later. Send it immediately, so that there's good proof of it. And then final question: if we have an applicant that tells us they have a medical marijuana card for disability, but we have a drug-free workplace policy, do we have to move forward with considering them for a position? So the medical marijuana card itself is not reason enough not to hire them, but you want to make sure that they're not on anything while they're working in your office. And that can be, a reason for not, hiring them. But you want to be careful, because you don't necessarily want to bring that up. If there's another reason you guys can't agree on employment, maybe rate of pay, maybe other things, then that might be the avenue out. But somebody can have a medical marijuana card. They can be have some disabilities, but it's important that they know that they cannot be on anything while working in the office, especially if they're a clinical employee. Maybe if they're front staff, if you want to be generous, maybe you allow that. But if they're a clinical employee, you absolutely don't want to do that. So these have been really amazing questions. I honestly, I think this is some of the best questions we've ever gotten, Adam. So I'm so excited to be able to do this with everyone. If anybody else has any questions, please email us at compliance@hrforhealth.com. If you have questions for me or the team, email us there, and then they'll either send it to me and I'll reach out to you, or they'll answer it for you. But thank you guys very much. We hope to see you soon. Be safe. And we look forward to hearing from you. Take care. Bye.
Great, thanks. I've actually got one more question for you quick that came in the chat.
Sure.
So I know you answered a COVID vaccine question at the beginning, but I guess number one, can you require your employees to take a to get a COVID vaccine, and two, if you can require it and they refuse, what does that mean?
Yeah, so you can require a COVID vaccine of your employees if you choose to, and depending on sort of their reaction, if they refuse, then it could become a termination, assuming they don't fit in one of the protected reasons. So if they can't take the vaccine because of medical reasons, or for religious reasons, then you do have to find an accommodation for them. But if they don't have a good reason for not taking the vaccine, they just choose not to take it, and you are going to require it of all your employees, then yes, you can terminate them. But as I mentioned before, please, any one of these kind of situations, guys, please pick up the phone and talk to somebody at HR for Health or me before you do anything like that. These terminations are super risky, and so make sure you're reaching out to us and making sure that you're doing things correctly. So
awesome. Well, thank you everyone for all the questions. We truly appreciate it. Ali, of course, thank you for your time. Great content as always. As a thank you for attending today, everyone will receive this recording of the webinar via email in the next week. Thank you all for joining us tonight, and we look forward to seeing you back here on future webinars.
Thank you, Adam. Thank you, everyone. Good night.
Thank you.